Good afternoon, everyone. Welcome to this week's discussion and update on COVID-19 webinar. I am Kathy Purdy, a marketing manager here at Schoeneck King. Two quick housekeeping items before we get started. Please enter your questions in the Q&A box located at the bottom of your screen, and we will do our best to answer those throughout the program. Also, your comments and suggestions for future topics are important to our attorneys, and we would appreciate you taking a moment to complete a brief survey once the webinar has concluded. So to start today's program, I'm going to hand it over to Pete Jones.
Kathy, thank you, and good afternoon, everyone. It's good to be back here with you. I'm glad you're with us today. We've got a full program again, so let's jump right in. We're going to start off today with Kate Shimowick. Kate is going to really take us back through the PPE, where we are. Jeff Shear was with us last week and walked us through. We had a lot of questions, and I think people are sort of interested in what's been going on. We thought it'd be good to regroup on that. So Kate, please take it away.
Thanks, Pete. It's great to be back here today talking about, just as you said, the PPP, where we are, and a lot of the questions that we've been seeing. As a general matter, it is now November. So most people, most of people who applied for the loan started back in April and May. So for a lot of borrowers, they are actually through their covered period and now looking at forgiveness. We're seeing a lot of questions about the forgiveness process, what that looks like, the actual forgiveness application, and now more recently, as discussed last week at length by our colleague Jeff Shear, we're seeing a lot of questions now about the new loan necessity questionnaire. So that, for a recap, for anybody who wasn't on last week, the loan necessity questionnaire are two forms, one form for a for-profit borrower, the other form for a non-for-profit borrower, in each case with loans over $2 million. And these new forms are going to be sent out by the lender, so not directly by the SBA, but by the lender, asking for more information regarding the loan necessity certification that was made with the original application. So we're seeing a lot of questions about that. We're seeing a lot of questions about the intersection of the loan forgiveness application and that new questionnaire. So without further ado, let's dive into some questions we've been seeing lately. So we're seeing a lot of confusion about the 8-week period, the 24-week period, and anything in between, right? So if you remember at the beginning of the program, it was 8 weeks was your covered period from the date that you received your loan funds. Then we kind of moved into an alternative covered period because it wasn't a clean time period. The SBA allows borrowers who have weekly payrolls or biweekly payrolls to instead use a alternative covered period starting on the first day of their first day of their first full payroll period following their loan disbursement date. In June, the Payroll Protection Flexibility Act was enacted, which then lengthened the covered period to 24 weeks. From there, we had a lot of questions about, okay, well, what if I used all my money in 14 weeks or 16 weeks or 22 weeks? So the SBA did release guidance on that. You are allowed to submit for loan forgiveness prior to the end of your 24-week period. So if you use up all of your money at week 16, you can apply at week 16. So we've been seeing a lot of questions about that. However, it's important to keep in mind, and this is something that was called out specifically in the SBA guidance, is if you have salary reductions for your employees, those salary reductions, those wage reductions are going to carry through as if it's the entire 24-week covered period. So just because you submit at say 16 weeks or 18 weeks, you're still, those salary reductions, if you've not brought those back and brought your employees back to their pre-COVID salaries, you're not going to get the benefit if you apply at 14 weeks and at week 20 you end up actually restoring salaries. You're not going to get the benefit of that. You're cut short. It's presumed to have carried through the entire covered period. So that's one thing to keep in mind when you're looking at your covered period. We received a lot of questions about the covered period itself and how it intersects with the loan questionnaire. So, things to keep in mind. It's not a just one factor, question about, what length of a covered period should I be using? You're really looking at a variety of factors. And these are factors that we can help talk you through if you reach out to us to really figure out the best strategy for your covered period. So, questions we're getting is, how long did it take you to use the funds? How are you using the funds? We've seen borrowers only use their funds on payroll and not include non-payroll costs into the calculation for a variety of reasons. One being documentation. There's less to provide there. There's also, questions about, like I said, that the 3509 and 3510, those are your loan necessity questionnaires. There's a lot of questions on there, as discussed last week and in the info memo that we sent out last week about it, that are asking, what really happened during your covered period. So if there are, there's questions on there about shareholder distributions, there's questions on there about capital expenditures and improvements that were made. If those things occurred during one covered period, but if you actually used a shorter covered period and you necessarily didn't have those expenses during that covered period, that's something else to consider when you're trying to decide what period you should really be using. Like I said, these are all things that we could talk through the various factors and things to be considering because it is very specific to the borrower. We're getting questions about timing, keeping in mind it's 60 days that the lender has to review your loan forgiveness application and submit it to the SBA. The SBA then has 90 days to review that application and then submit the funds back to the lender to then be used to pay down your loan. However, we're seeing very quick turnarounds that are more looking at 6 weeks, something like that, compared to 2 months ago. It was literally at a standstill. Again, when it comes to the 3509 and 3510 forms, keep in mind these are only forms that are going to be sent out by lenders to borrowers who have loans over $2 million. We're seeing a lot of questions about that. Keep in mind, if you're under $2 million, you don't have to worry about the form. And we're seeing questions about documentation. What type of documentation do we need to provide? Our suggestions are answer the questions that are being provided to you, that are being asked of you. Provide the lender the information that directly relates to the answer that you're providing. Don't you want to make sure that the information you're providing the SBA and your lender is accurate. That's the most important thing right now, is making sure you're providing accurate information, making sure the information that you're providing matches up with your internal records, because you don't want to provide the SBA information that later during an audit does not line up with the information you have internally. Other pitfalls we're seeing with loan applications, keep in mind that your covered expenses that you are submitting for are in fact allowed under the guidance. We're seeing things like life insurance being included into the applications. That's not a covered payroll expense. Your benefits are only 401k, health insurance, vision, and dental. Life insurance is not included in there. And also make sure that when you have benefits that are paid partially by the employer and partially by the employee, you're not accidentally included them on 2 different lines. So make sure there's no double dip accidentally happening when you're doing your applications. One final update is late last week, there was a court ruling that came out indicating that the SBA has to release loan data about all loans. So if you remember, over the summer, there was a huge amount of information released by the SBA for loans over a certain threshold, name of the borrower, how much the loan was, and there's now been a court decision saying that loans under that threshold now also have to be publicly disclosed. So that's something on the horizon that we're keeping our eyes on. So once again, if there's questions about any type of strategy and how the loan questionnaire plays with the loan application and figuring it all out, please give us a call. We're here to help. Thank you.
Kate, it strikes me, it's a lot of information. It strikes me that everyone I think I would take two pieces of advice from what you said. One is, you have to evaluate your individual situation and figure out, where you fit. And the second is make sure that you're, truthful and accurate and, careful with your representations. There's a lot of different permutations here, but those are kind of the high level takeaways, at least as far as I could tell. Is that a fair statement?
Absolutely. Yes. Those are the two biggest things right now is, like I said, make sure the information that you're providing on the questionnaires, your application form, the documentation you're adding in with that is accurate. And yeah, absolutely. If you've got questions about any of this, please reach out and ask, because there's a lot of facets to it to consider.
Great. Okay. Thank you. Appreciate that update. We're going to turn now to Jen Swarzout. Jen is in our Rochester office. Periodically, we just talk a little bit about what's going on in the litigation world with specific focus on COVID litigation issues. And there are a few developments as we've moved into fall here. So Jen, please take it away.
All right. Thanks, Pete. It's nice to be with you, everybody out there. The courts, there are some updates that I think is worth noting. And I think it signifies, unfortunately, where we're heading, and we'll probably hear more from Katie Anderson about that towards the end of the program. But with regard to trials specifically, the state, of course, at the beginning of last spring had really put a shutdown on most of court proceedings that were occurring in person. And over the late summer and into the fall, that had been starting to be relaxed a bit. And in some jurisdictions, certainly in parts of our state that are a little bit less populated, they were proceeding with trials. And to be specific, we have, as some of you might know out there, or some of you might not, but there's what's called bench trials, which is just the judge and the parties. And there's jury trials, which is where you have the folks who make the decision who sit over in the jury box. So bench and some limited jury trials were going forward until last week. The head of the Court of Appeals, which is a reminder, the highest court in New York, Judge DeFiore, made the decision to cease all trials in person. The trials that were happening at that moment in time were allowed to continue to completion, both civil and criminal trials, and bench trials as well. But any new trial scheduled is put on hold. And notably, this even includes bench trials that will now need to be done virtually, which is significant because that is jury selection certainly involves a great deal of people and through that process. But the numbers that were coming through with people who are testing positive, both people coming into the courthouse and staff, was just getting to kind of an unwieldy number. So that decision was made just last week. In fact, if there is a website that the court maintains, and I just was scrolling through it, the number of cases that are being reported by court personnel throughout the state is quite significant. And it surprisingly is not just downstate. It is in many of what we would historically consider more rural areas of the state, upstate, are having a lot of reported cases as well. So we'll probably hear a little bit more about that from Katie. So going forward, what does this mean? It means that if you had a trial scheduled in the next couple of months, it's probably not going to happen. If it's a bench trial, it might happen virtually, and the court system has been getting better at doing that process. But it's important to bear in mind because there's civil and criminal cases. As you may know, there's constitutional protections with regard to criminal cases that puts them in a preference, so to speak, because there's speedy trial rules. So to the extent trials are going to happen virtually, and when things get back open again, hopefully, the criminal trials need to have preference in that regard. So I'm sure if you have trials pending, whether it's an attorney at bond or someone else, I'm sure you'll be hearing about the delay. Another change that's just happened in the last couple of weeks is regard to limitations periods, or what we call statute of limitations. Limitations periods are various depending on the type of case that you might have, but they are the time period within which someone can file a lawsuit against you and have it be valid. For example, if you're in an automobile accident in the state of New York, you have 3 years from the date of that accident within which to file a lawsuit. If you file it after that, the court can dismiss it out of hand. That period of limitation has been extended from March until November 4th. So now, at least as of this moment in time, that extension, if you will, has been returned back. So if you had a case that would have otherwise been due, you had to file by August, you could have done so September, October, up to November 2nd or 3rd, and then now that has been taken away. Whether it's going to be something that will be revisited, that's certainly possible. But as of right now, those are things that do need to be timely filed. There are some colleagues of ours who are thinking about creative ways and suggesting maybe that those 200 plus days should be added on from November 4th. And that's certainly an argument that could be made. But I think the safest bet is to assume that your periods of limitations are running as per the statutes as they're required. And then another issue related to legal theories that's COVID related, immunities. So one of the things that you should all know that's happening is that the State Bar Association has convened a task force of attorneys to kind of come up with and theorize what are the potential avenues that might, or entities that should get immunity protection. I happen to be on the task force. I'm one of the co-chairs, and so I'm involved with that. But it's attorneys from all facets of practice on both sides that represent individuals, commonly referred to plaintiffs' attorneys, or in labor cases, the employee side, as well as folks who do management side, and investigating insurance companies, municipalities, schools. And so this group of attorneys is endeavoring to figure out what are some of the things that should be contemplated for immunities. Do certain entities, should they have immunity? Maybe municipalities, for example, who are strapped on resources, but have all of these additional requirements they need to provide, whether it be PPE and that sort of thing. Is that something the state legislature should consider? And so that is something that attorneys, you should know, are working through. Currently, there is a immunity for medical malpractice, in the sense that medical providers who are providing COVID-related care, the state recognized back in April that was important to have an immunity related to that. So that is something that already exists. And that is whether there should be something similar is being contemplated right now. So if you have some ideas, if you're a business or an entity that you think is worth considering having an immunity, please reach out to your bond attorney. You can also reach out to me, and we will be sure to have the task force contemplate those sorts of things. But we'll get back to you probably at a later. This probably is going to take some time, but I'm sure maybe if I ask Pete, he can invite me back, and we can give you an update as that work continues to go forward. So with that, I'll turn it back to you.
You have a standing invitation anytime you want to come join us.
All right. Thanks, Pete.
That's actually a very interesting project. And it's great that you can get the feedback, but obviously there'll be a lengthy process in terms of what the output is.
Absolutely.
Yeah. Okay, thank you. Appreciate the update. Something to just keep our eye on. Okay, so there's been a lot going on. I think nobody's in good shape, or we're all sort of trending in the wrong direction in New York State and beyond. So, Katie, why don't you take us through, some of what's going on, the numbers, and some of your other observations.
That I will do. Hello to everyone. Thanks again for being with us on this beautiful Tuesday. Let's start first with my favorite topics, an executive order. This executive order was issued last week. This order has come under a lot of sarcastic comments. This order has restaurants, gyms, bars, liquor stores all have to effectively close, even though restaurants and bars may still serve food via delivery or with curbside pickup after 10 p.m. Lots of people joking, oh, does the virus stop coming to the door at 10 p.m.? Well, actually, the most popular times for bars is at 10 p.m. People drink and people don't care about wearing masks. So this has become, as funny as it seems, it's actually, there is a reason behind this, especially when you think about next week, the Wednesday before Thanksgiving is the most popular drinking day of the year. So that is one of the reasons why this was put into place. I thought that the context would be interesting for you. The other part of this order that's also gotten a lot of attention lately is the non-essential gatherings in private residences are capped now at 10 people. This creates tension, or at least different treatment between events held in public spaces versus events held in private residences. So, for example, in my apartment, I could host an event, and I wouldn't, but I could have up to 10 people in my apartment at a time. If I was going to have a party for some reason for myself, I could go to a restaurant in Albany and say, I'm going to have an event for 50 people. That would be allowed. So it creates this tension between those orders, but this has existed and is now becoming more and more popular in other states. I put the list there of other states that have similar orders to this. Some of those states, you can't even have a gathering or at all in public or private. But there's variation from state to state, but I thought it was important because this has become a hot topic issue. There's lots of sheriffs throughout New York that are saying, we're not going to enforce this on Thanksgiving. That's just a lot of, bluster that's happening, that it just doesn't cut to the chase. This is becoming a popular thing to do in states, and that's why it's coming up now. Obviously, it's coming up before Thanksgiving. There's a purpose for that. We're trying to prevent lots of people from being indoors from different households. So that's what that executive order did. Another executive order was issued early this morning. It just, extends other executive orders. It's not a big deal, but we are now at 202.75. So that's the executive orders. Let's move to clusters. There are 13 active clusters in New York State at the moment. I have I'm going to go through some of them in more detail than others, because some of them things are moving very quickly. And, Broome County, for example, that Broome County cluster zone has been in place for almost a month and a half. That one is the one that really hasn't changed at all. The positivity rate really has remained pretty similar from when it was designated to now. But that's just something to be looking out for. These clusters designations may be around for a long time, more than just, a 3-week period. Looking at, I'm going to just point out one more on this list, and then we'll go into depth about the ones that people really want to hear about. Tioga County, it's a small part of Tioga. It features on Waverly, the town of Waverly. It's right on the Pennsylvania border. They've really seen a high number of cases. And now we're going to talk about Monroe, Erie, Westchester, and Onondaga counties. We've got some issues there, and they need to be pointed out. So this is, and if you're looking at the bond updates about the cluster zones, this is in that article. So feel free, don't feel like you have to scramble to screenshot this. When I'm done, I'll put the link in the question and answer thing, so you'll take a look at it. This is what New York State has laid out about why we have different cluster zone designations. I included just tier 1 and tier 2 because that includes Erie, Monroe counties, and Onondaga counties. It also includes specifically Buffalo, Rochester, Syracuse. So I collected this data from the website from New York State. Right now, we'll start with Erie County. Erie County's cluster zone has a 7-day rolling positivity rate of 7.26% with 44 out of 100,000 new daily cases on a 7-day average. We take a look at this chart, we see that data appears to qualify Erie County's cluster zone as a red zone. So, that's not to say that this is definitely going to happen. Well, I'll obviously put that caveat in there. I'm not always right, despite what I may think, but this is a heads up. This is likely coming. Same thing with Monroe County. Monroe current day has the 7-day average of 5.3% with 33 out of 100,000. They are in that tier 2, so they are right on the cusp of being in a red zone, but they would also qualify for an orange zone at this point. It seems, they're going to be right on the edge of where they're going to be. So keep your eye out for that as well in Monroe County, but Rochester itself may qualify for, it could be either or. It could be separate from the Monroe County designation. Same thing with Onondaga County. Onondaga has a 6.53% positivity rate at the moment with 41 out of 100,000 cases over that 7-day average. That is, we are getting very close here. It's qualifying right now for the tier 2 red zone, just based on those observations. We're very close to the edge there. Westchester County. Westchester's at 9.01% positivity rate over 7 days. And it has that 31 over 100,000 cases that are new over the 7-day average. Now, one thing to note here is the data on this is a little confusing because there is that extra line in all of this that says that the rolling positivity rate has to be over a certain threshold. The 7-day average has to be over a certain threshold for 10 days. I think we've reached the 10-day mark now for a lot of these places. And I keep furiously checking to see whether or not the governor is supposed to speak. He is not currently scheduled to speak today, but I will be obviously keeping my eyes out. And I think that this is likely coming down the pipeline. So please be prepared for that. I would be preparing for that. And in anticipation of questions, I decided, this is a good time to go through what does it mean to be in a red zone? What does it mean to be in an orange zone? Red zones, no non-essential gatherings of any size may occur. Remember, non-essential gatherings include everything from meetings to just parties. It's everything. They cannot occur. All non-essential businesses must reduce their in-person workforce by 100%. We're going back to March on this one in a red zone. We're going back. Even though the essential business list is much longer, it's much different now. We're going back to that. All houses of worship, there's new capacity limits on them. Restaurants, they have to close down for only to-go and delivery. And then schools, there are specific protocols to follow if schools wish to remain open for in-person instruction. Orange zones, all non-essential gatherings limited to 10 people. Now, one thing to note, and I didn't mention this earlier when I was talking about the private residential gatherings, but that 10-person limitation in private residences applies statewide. it applies whether or not you're in a cluster zone. But if you're in a red zone, you still have that 0-person limitation you have to follow. Go with whatever's smaller. Non-essential businesses like gyms, personal care, they all have to be closed for in-person work. Again, you have the limitations on schools. Outdoor dining is allowed, but only 4 people may be seated at a table. And again, the restrictions on religious gatherings. So that's a lot of information about clusters. I will put up that link to go over. And Jen already summarized beautifully these court changes, so I will skip right ahead. This is just a slide about it if you really want it. One last thing to note, last week we saw the first real case that was has come out positively for a plaintiff in a long time against the administration, the Cuomo administration. There was a state liquor authority rule that said that licensed premises, which are all, anybody who sells alcohol, cannot advertise for music events, and they could not sell tickets for those events. There was a lot of different reasons why this was struck down. In my opinion, the one that's really going to stick is likely the First Amendment, that this is an infringement upon speech. That means that we've had 2 cases now relying on the First Amendment to strike down these limitations. The power that the governor has right now is enormous. The state police power is enormous, but the one check appears to be the First Amendment. And with that, we're done.
Katie, let me just ask you 2 quick questions. Going back to the cluster.
Yeah.
When each day, if there is a pattern, do the new announcements come out, and when are they effective?
Yeah, that's a great question. So there is really not a pattern for the announcement of cluster restrictions. Generally, though, the governor will have a press call with the media. I typically, through my back channel ways, am able to join those calls and listen in. So, I find out pretty quickly when they're going to happen, but that's generally how he announces it. I also noticed that when you put out, the later in the day he goes without saying anything, the less likely it is that something's going to be happening that day. He does not really do a lot of afternoon things, and I'll say that now and watch. He'll announce that he's having a 2:00 call. But there's really not a strict pattern that he follows.
Okay. And effective what? Immediately or 2 days hence, or what's the pattern?
It's usually 2 days, 2 days in the future. But it varies. That's generally what it is.
Very good. Thank you. All right, let's turn to Kate Reed. As these things evolve, we thought we'd give you a little update on what's going on in the school front. Kate, please take us through that.
Sure, thanks, Pete. So there's a lot going on the school front, as there typically is. So I wanted to give everybody an update of some of the issues that schools are facing right now. Nice segue from what Katie was talking about. We have a whole panel of Katies today, so it's hard to keep track of everybody. Katie Anderson was just reporting on the distinctions between the orange and red zones. So in terms of what that means for schools, I want to give just a little bit of a recap, because testing is what is on everybody's mind right now. Orange and red zones cannot offer in-person instruction unless 100% of their in-person staff and students are tested. Yellow zones, which are a lot of what's on the map right now that Katie went through, testing must be conducted of at least 20% of in-person students and staff. Now, the Department of Health just issued guidance that provided a little bit of a reprieve from that requirement for yellow zones on November 12th. So effective the week of November 16th, this week, schools in yellow zones must test 20% of in-person students, faculty, and staff over the 2-week period immediately following the announcement of their designation as a yellow zone. But of interest, if the results of the testing reveal the positivity rate among the 20% of those tested is actually lower than the yellow zone's current 7-day positivity rate, testing is no longer required in order for in-person instruction to continue. So this appears to be a recognition that in some communities, schools are a driver of COVID-19 spread. and in others they are not. So what the Department of Health seems to be doing is affording flexibility where it is clear that the data does not support that school is a significant factor in contamination, to provide some relief of that mandate of testing. We've had a number of questions arise regarding testing for schools. It's a complicated process. Previously, when I've reported to this group, I've explained that school districts by law do not have the authority to conduct their own testing. In order to do so, they have to become licensed by the Department of Health as limited service laboratories. Anecdotally, based on our representation of close to 70 school districts across the state, there are not many that are going in that direction. Although the initial application process to become a limited service laboratory is not terrible per se, the bookkeeping and auditing requirements and paperwork that's required once that status is achieved is really very, very burdensome. So in practice, what we're seeing is that in terms of the who is conducting the testing, in most cases, that's the local county DOH office, the local Department of Health. Schools are collaborating with the DOH to set up testing sites and locations on school premises or at another location to conduct the testing that's required by this yellow zone mandate. Another important consideration, as I've reported on before as well, is that consent under our public health law in New York State is required in order for a school to conduct medical testing of a child. So what does this mean? It means that schools don't have the authority to condition school attendance on a parent consenting to testing. If a parent says, no, I refuse to conduct the testing and have my child subjected to COVID-19 testing, that cannot be a basis for excluding that child from school. Consent is a mandate. So many districts and schools, as they're approaching those numbers, like Katie was saying, there are many now that are also on the cusp of becoming yellow zones. We're encouraging them to be doing this groundwork right now in anticipation of that designation, to be collaborating with their local departments of health to get a plan in place for how the testing is going to be conducted, and to take care of the administrative hurdles to conducting that testing before the mandate is upon them. And what I mean by that specifically is obtaining parent consent in writing so that they may move forward with testing once the mandate is required. So some might ask, well, then what happens in my local school district if I consent to my child being tested, but my neighbor does not? What does that mean? Well, in essence, what it means if you're in a yellow zone is that unless that school district is able to get up to that 20% threshold of parents that consent, that school is not going to be able to conduct in-person instruction. So as I said, consent is required and attendance in school can't be conditioned on compliance with that consent requirement. So a lot of districts that we're seeing that are already in yellow zones are doing the effort of explaining to parents what testing will actually consist of, who will be doing it, when it will occur, and explaining the consequences of refusing to test. In other words, not that the child will be excluded from school for the failure to test, but explaining that if the district does not hit that threshold 20%, that may endanger their ability to conduct in-person instruction. So testing is really front of mind for a lot of schools right now. Some welcome relief for school districts came in a decision issued by the Southern District of New York, the federal court that has jurisdiction over New York City and parts of downstate. This was a very high-profile special education litigation that was brought by the Brain Injury Group, an advocacy group in New York City. And interestingly enough, this case was brought against all districts in New York State and all districts within the country based on a federal law, which is called the Individuals with Disabilities in Education Act. So the essence of the theory of that case is that when the governor closed schools in March, that by necessity terminated in-person special education services. So of course, if districts cannot interface with kids in person, they're not able to deliver in-person services to special ed kids. So the plaintiffs in this Brain Injury Group case were essentially asserting that by failing to deliver special ed during the school closure, that amounted to a violation of federal law and a basis for relief by every disabled child against every school district in the country. Now, there's obviously those of you who have an eye a litigation brain are probably listening to this and saying that sounds absurd, because how can a single court have jurisdiction over every school district in the country? And the simple answer is they don't, which is partly why the court on their own initiative ended up dismissing a large proportion of the plaintiffs of that group. But then also, of surprise, even to the downstate districts, on Friday, we got a decision from the judge in that case dismissing the case in its entirety as failing to state a claim. And the main basis for that dismissal was the ground that essentially our federal Department of Education expressly blessed and encouraged districts to deliver remote instruction during the school closure. So their compliance with that mandate could not have been a violation of federal law. So as I said, in the midst of mass chaos and confusion regarding testing and unfunded mandates connected with testing, this was some welcome relief in the litigation realm from in terms of districts' special education obligations. So what are we thinking about as we move forward? Coordinating with county departments of health is going to be absolutely essential as more and more counties are added to yellow zones. We've heard concerns from our schools regarding capacity for testing. Do we have enough testing kits? Do we have enough testing capacity? If more and more counties in the state become designated yellow zones or orange zones for that matter, where testing is going to be a mandate, will the local county health departments be able to continue to provide that support? Or at a certain point, are schools going to have to conduct that testing themselves? Big question that remains to be answered, which is why it's really important that schools coordinate with their local regulators to have a plan in place for if and when they are added to to a cluster. In anticipation of that, we're hearing a lot of scuttlebutt, particularly from our downstate districts and neighboring districts downstate, that many schools are contemplating actually voluntarily switching to remote instruction fully upon return from the Thanksgiving break. There's concern that as people are traveling and coming back, that is going to present a unmanageable risk of infection, and that there's an interest on the part of a lot of districts to saying, we don't want that liability. We don't want that the management concerns and the administration concerns in conducting the testing to manage that situation. So as we reported way back in the summer, schools were required back in the summer to supply to the state education department reopening plans that included essentially options for how they would implement either in-person, fully remote, or hybrid, in other words, combination instruction. So many schools are saying, we're going to make that choice when we come back from Thanksgiving to switch entirely to remote instruction in the interest of safety. So there's going to be a lot of considerations if that happens. Instruction is going to need to be implemented in accordance with the reopening plans, of course. The state guidance no longer allows districts to just kind of give worksheets to kids, for instance, during a closure and satisfy their obligations. They're required to ensure that students are receiving regular, substantive, robust instruction that will help them achieve state standards. And there's other potential consequences as well, including the grim budgetary outlook that districts are facing, which may necessitate layoffs and furloughs. So that's about it for the school world right now, Pete.
That's enough, Kate. That's quite a bit. So thank you for that. We're going to turn now to Frank Mayer. This may be surprising to people, but we've had a few technical difficulties, so I don't believe we're going to have any video for Frank today, but hopefully we'll have audio. And I asked Frank to talk a little bit about working remotely from outside of New York, some of the tax and registration considerations. So Frank, go ahead, take it away.
Hello. Yes, thank you, Pete. So the COVID-19 situation has accelerated a trend that's already existed in the workplace, and that is employers find themselves with the need to draw on a wide range talent pool that often goes beyond their physical location. And that provides, of course, opportunities as well as certain responsibilities and challenges. So I'm going to speak sort of in a hypothetical way, talking about a New York employer, for example, that might hire someone who is out of state, let's pick Pennsylvania. It doesn't mean that these are the New York, Pennsylvania rules, but they're for illustrative purposes. So let's say that the New York employer hires somebody in Pennsylvania, or a person who is a New York employee for a New York employer moves to Pennsylvania. So as a general rule, wages are subject to taxation where the worker is situated. In other words, even though you may have a New York employer, if an employee for that New York employer is performing services at their kitchen table in Pennsylvania, and even if the New York employer has no other contact with Pennsylvania or any state for that matter, the wages are still deemed to be considered Pennsylvania source wages, because that's where the employee is sitting when they're performing the work. You know, if it's through an internet connection and that's the only contact, that's sufficient. So what does that mean for an employer? Well, that means for an employer that they do have a wider, broader workforce, but the responsibilities include registering to collect, withhold income tax in the state to the extent that the state has an income tax. You know, some of the more frequent states that employers deal with, at least New York employers, are Texas, Florida, and some other, Tennessee, that don't have income taxes. But for the most part, states do have income tax and are required to withhold on the wages of their employees. So what that means is that the employer sets up a tax account in the state and withholds on the wages, files quarterly tax returns, much as they do when they file as a New York employer, file their New York State 45 employment tax return. In addition to wage withholding, the employers typically need to provide the benefits that are required in the particular state. So, for example, that would typically mean at a minimum workers' compensation and unemployment insurance. So we see this New York employer with no contact whatsoever in another state, say Pennsylvania. Suddenly they have this worker there sitting at their kitchen table, and suddenly the New York employer finds itself with the obligation to withhold income taxes, provide workers' compensation, and unemployment insurance. But wait, there's more. New York is an interesting state. It has what's called a convenience of the employer rule, and it's one of the few states that has really long arms when it comes to wage withholding. And it's policy that's been in place since 2006, and it's based on a Court of Appeals case called Huckabee, says that if an employee is working out of state for their own convenience rather than out of necessity, the employer's necessity, all, and I repeat, all of the wages paid to that out-of-state employee are subject to New York withholding. Well, what does that mean? Well, what that means is that those wages are going to be subject to the, let's say, in our example, the Pennsylvania withholding, but would also be subject to New York withholding. So the employee finds themselves with, wow, I've got to pay withholding tax, income tax in my own jurisdiction, but I've also got to pay tax to New York. I don't even live there. But the New York convenience rule is something that has bedeviled New York employers since 2006. And some people might say, well, that's not so bad because the employee, and we're not here to give employees advice on their tax returns, nor should we ever do that. We only encourage employees to consult their own tax advisor. But because New York imposes this tax on out-of-state telecommuters generally, unless they meet the requirements, on stringent requirements, which I won't go into here, the employee pays tax in both jurisdictions and does not, I repeat, typically does not get a credit for the tax they pay to New York State because the services were performed in the local jurisdiction, Pennsylvania in this example. Had that Pennsylvania employee gone to New York and worked for a month, Pennsylvania would likely give a credit for the month that the worker is performing services outside the home state, and they would give a credit for the New York income tax withheld for that particular month. But in absence of that, if New York imposes an income tax on a Pennsylvania resident performing services solely in Pennsylvania, the employee is in for subject to withholding for both New York and Pennsylvania. So many New York employers have found themselves in the awkward position on a routine New York State payroll tax audit when the New York State auditor will say, okay, show me your federal 941, your payroll tax return. Then the client will produce the payroll tax return. Then the auditor will compare that with the New York 45, and they find out that the batch totals don't match. And then the auditor asks, why don't you withhold New York tax on all your employees? Well, some work out of state. And then an analysis is done of this convenience of the employer test. And in most cases, it results in an assessment for uncollected taxes in New York State. Having employees work in another state also creates other responsibilities for the employer, not the least of which is called creating nexus or a taxable presence in that state. So just because this New York employer has a single employee, for example, working in Pennsylvania or some other state, most states deem a single employee, even a back office employee working in a state, sufficient to create nexus for state income tax purposes and sales tax registration. Even if you're not in the business of collecting sales tax, there'd be requirements to register and opt out. So it goes beyond just responsibilities for payroll withholding, but responsibilities to possibly file a corporate income tax, state income tax return in the jurisdiction where the remote employee works, allocate or apportion, as they say, some of the income away from New York and towards the jurisdiction where the employee is performing the services. Beyond that, typically the organization would have to also file an authorization to do business in state. That's not a filing with the state tax department, the local state tax department, but a filing with the Department of State in the out-of-state jurisdiction, basically meaning that because they have an employee in the state, they're deemed to be transacting business in the state. And so they have to, an employer finds itself having to register and pay a nominal fee. In addition, not-for-profit employees, employers typically find themselves with obligations to register with a state charities bureau, even if it doesn't have any particular obligations beyond just letting the state know that the employer is there. So again, the responsibilities for having employees out of state are typically employee income tax withholding, providing workers' compensation, unemployment insurance, addressing the New York convenience rule and possibly withholding New York State income tax as well as local income tax, doing a nexus review to determine if the presence of the employee in the state has created a taxable presence for corporate income tax purposes, registering as authorized to do business in state, and in the cases of charitable organizations, possibly registering with the Charities Bureau. So in the COVID situation, there a few states have passed some grace periods. I know New Jersey and Massachusetts has some narrow exceptions that allow employers to avoid some of this peril for 6 or 9 months, but that really is dependent on a kind of a facts and circumstances analysis of the employer's individual situation. But for the most part, these general rules that I've explained, if there's not a short exception available out there, stand. So that's really what I have on out-of-state withholding and reporting obligations, Pete.
Frank, thanks. It's to hear you talk about it, you explain it very simply, even though it's a little bit complicated. My short takeaways, though, are it's a trap, potential trap for the unwary. We ought to be looking at those short-term COVID exceptions. Hopefully they will apply and get us through that. But to the extent the world has changed, and I think it has for a lot of us, these are going to be longer-term issues that we ought to be taking a look at.
I would agree with that, Pete.
Okay, thanks, Frank. And thanks everybody for being with us today. We really appreciate this. We'll be back next week, and we're going to continue to do pop-ups as well. We want to help you through this difficult situation. Everyone, please stay safe, and we'll talk to you next week.